Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to finish up our discussion of the Cockerham case, and we're going to talk about the last appeal in that case. So stay tuned. Before we get started too far here, I want to make sure everybody understands this is talking about one case. This is not how American Family acts in every case. As surely as night follows day, American Family appealed the verdict against them for vexatious refusal. Now, it could be because they thought it was wrong, or it could be because it was $1.4 million and they didn't want to pay it. Whichever it was, whether they wanted to leave their money in the bank longer or what, the bottom line was they had almost no legs to stand on when they took their case to the Missouri Court of Appeals for the second time. So they really only argued two errors, but they did it in four separate points on appeal. And I won't trouble you with going through all of the wordage of the points on appeal. The first point on appeal dealt with the trial court granting judgment. So their point on appeal was that, first of all, an objection was a sufficient response to a statement of fact in a summary judgment motion. And the second part of that was that the opinion of the court provided only for a judgment as to coverage. And that is not what the opinion says. You can go on the Missouri Court's website and you can find Cockerham versus American Family. And you can read that opinion and you can find out exactly what the opinion says. And it says absolutely nothing about a judgment for coverage. It says a judgment for their losses, which of course means monetary damages, right? Well, that's what anybody reasonable would think, but that's not what American Family thought in this instance. So the second part of it was they said that the mandate that the court had issued on the first appeal required a trial on vexatious refusal. And they got there by saying, well, the issue is whether or not the denial was proper at the time that it was made. And that's not what Missouri law says. Missouri law says that after an insurer becomes aware that it has no meritorious defense, it is liable for vexatious refusal to pay. And that was the claim that we advanced, and we advanced it by summary judgment. And what they said was, no, you have to follow the mandate. You have to follow a trial. You have to have a trial because that's what the mandate required. So let's deal with these in sequence. The first one about the judgment was just pure bunk. And in fact, the Court of Appeals for the state of Missouri basically said their argument was, quote, wholly unavailing. I thought that was a very nice way of calling the argument that they made frivolous. But at any rate, the judges who entered that opinion said, no, there was definitely a judgment for money damages. The court entered the judgment correctly, and you lose on points 1 and 2. Now, at oral argument, when we went to oral argument, one of the judges had a real problem with the fact that the mandate said, in her opinion, that we had to have a trial on damages. And I explained to the judge at the time that the mandate was issued at a point in time before the subsequent conduct that resulted in this second summary judgment motion. I explained to the court, look, a mandate doesn't have a crystal ball attached. I basically said to the court that a mandate does not have precognition. It can't know what's going to happen next. So as a result, it couldn't possibly have covered the situation that was before the trial court. And one of the judges had a really hard time with that. She did not understand how I could get there. And one of the things that you have to admit when it's true is that you didn't do a good job. And I didn't do a good job of explaining my position, at least to her. One of the other judges understood, and one of the other judges did what I should have done, which is he went back to the actual text of the mandate. And it didn't say hold a trial on vexatious refusal. What it said is conduct proceedings consistent with this opinion. And it was completely consistent with the opinion to have a second summary judgment on vexatious refusal based on conduct that occurred after that opinion. And that was ultimately where it went. The court gave us the judgment that we were entitled to and has remanded it back to the trial court for additional, for collection. Now, again, they will get an opportunity to file a motion for rehearing. And when they file that motion for rehearing, I will probably discuss it here. They will also get an opportunity to file an application for transfer to the Supreme Court. And when they do that, I will probably discuss it here too. I don't expect for either of those two things to go in their favor. But at the very least, I do feel like I have an obligation to you, my loyal listeners and readers and everybody, to at least be able to tell you the whole story and have it all be done. So that's sort of the convoluted situation of poor Mr. Cockerham. The original claim arose in 2005. It is 2021. It is 16 years after the original damages and claim were started. And we still have not received a dime from American Family Insurance. Now again, I want to make sure everybody understands this particular issue. This is one case. It involves one set of facts. It does not mean that American Family always does this. In fact, it means that you should not ever consider that how an insurance company does something in one case means that they're always going to do that, because it's not how the world works. Different adjusters, different people in the insurance company have different ways of looking at things. And so you needn't be too concerned if you have American Family that they're going to just willy-nilly deny coverage on things. But by the same token, read your policy, understand what it covers, and more importantly, understand what it does not cover. That is a key thing. If you found this interesting or helpful, I would really appreciate it if you would smash that like button for me. That lets YouTube know that this is worthwhile information for other folks. I'd love it if you'd go over here and subscribe to our channel if you haven't already done so. And if you have any comments, leave them in the comments down below. I always try to interact with people on the comments. Thank you so much for watching, and have a terrific day.